Can the President of India refuse to act even when the Constitution expects a decision? Can a state law be stopped without ever being formally rejected? For many years, this is exactly what was happening in India. This situation is known as the pocket veto. But in 2026, the Supreme Court stepped in and examined this issue very closely. What emerged from this is one of the most important constitutional developments for UPSC Prelims 2026. Today, I am not going to teach you articles as isolated facts. Instead, I will help you understand the system behind the constitutional conflict. To understand this clearly, imagine a simple situation. Think of a state bill as a car trying to move forward. This car reaches a signal, and that signal is the governor. The state bill does not automatically become act without governor assent. So this car reaches a signal, and that signal is the governor. The entire process operates under Article 200 of the Constitution. That is, governor may give assent or return the bill for reconsideration and reserve for the bill or bill sent to president. This may happen when after the assembly pass a bill. At this stage, three things can happen. First, the governor can give assent and the bill becomes law. The second one, the governor can return the bill to the state legislature for reconsideration. And third one, that is the governor can reserve the bill for the consideration of the president, which happens under Article 201 of the Constitution. Now, this is where the real problem begins. When the bill reaches the president, the Constitution does not prescribe any fixed time limit within which the president must act. When the bill reaches to the president, the Constitution does not prescribe any fixed time limit within which the president must act. The president may give assent, the president may withhold assent, but the Constitution also allows a situation where the president simply does not take any decision. This situation where there is no clear yes and there is no clear no is known as the pocket veto. May give assent or withhold assent or keep it silent without any action. This is called pocket veto. Now let us understand why this issue became so important recently. Several state governments began raising concerns that their bills were being delayed for a very long time without any clear decision. Example, tussle between Tamil Nadu governor and the Tamil Nadu state government. Tamil Nadu governor may send 10 more than 10 bills for reconsideration. This is just example. They argued that this kind of delay was affecting the functioning of democracy. Like The state governments argued like this. This kind of delay was affecting the functioning of democracy. The Supreme Court initially responded by stating that such delays are problematic and that decisions should ideally be taken within a reasonable time. However, the situation took a significant turn when the President of India invoked Article 143 of the Constitution. Under Article 143, the President has the power to seek the opinion of the Supreme Court on questions of law or fact. Under Article 143, President have the power to seek opinion of the Supreme Court. It is very important to remember that the opinion given by the Supreme Court under Article 143 is advisory in nature and is not binding on the President. President may be act on that, otherwise leave it. There is not binding. There is no binding. Strictly advisory in nature. The President essentially raised a fundamental question. Can the judiciary impose strict timelines on the President for taking decisions? Asked the President in the form of Article 143. True. In other words, the Supreme Court act as a timekeeper for the executive. This was not just a legal issue. It was a deeper constitutional question about the balance of power between the executive and the judiciary. The executive is president and the judiciary is Supreme Court here. The verdict is, now let us understand the final position that emerged from the constitutional interaction is, this is most important part from the examination perspective. The verdict. Supreme Court gave three statements in their verdict. Importantly, for examination point of view, the Supreme Court clarified that it cannot impose fixed timelines on the president or the governor. This is because doing so would violate the principle of separation of powers. This is also basic structure of the constitution, separation of powers. And second point is, the court made it clear, very clear, that there is no concept of deemed assent. A bill does not automatically become a law simply because there has been a delay. There is no concept of deemed assent in the constitution. And the third one is, and the most importantly, the court stated that while there is no fixed timeline in the constitution, delays cannot be definite, indefinite, or unexplained. Absolute silence not allowed here. And the third, most importantly, the court stated that while there is no fixed timeline in the constitution, delays cannot be indefinite or unexplained. Have to be explained. In simple terms, the constitution may be silent on time limits, but it does not permit absolute inaction. There is no fixed timeline, but there cannot be indefinite delay. This is golden line. Remember this clearly for the examination purpose. What is that? Let me repeat it once again. There is no fixed timeline. There is no fixed timeline, but there cannot be indefinite delay. But there cannot be indefinite delay. In the UPSC examination, questions will not be asked as a direct or theoretical manner because we are going to prepare the examination. So we have to think like that only. Instead, UPSC will test your understanding through carefully designed traps. Let us identify the most important traps are three traps more are there. Trap number one is the president must act within a fixed time limit. The statement is incorrect because constitution does not prescribe any such timeline. And the trap number two, that is the advice given under article 143 is binding. This is also incorrect because article 143 provides only advisory opinions. And trap number three, that is a bill becomes law automatically after delay. This is again incorrect because there is no concept of deemed assent. The correct understanding is this: indefinite and unexplained delay is not constitutionally acceptable. This is now UPSC. This is how UPSC evaluates your preparation. It is not testing your ability to recall information. It is testing your ability to identify and eliminate wrong statements under pressure. Now remember one thing very clearly. This issue is not really about articles or technical provisions. This is about who ultimately controls the legislative process in a constitutional system. It is about how far constitutional silence can be used as a tool of power. UPSC is not testing your memory. It is testing your ability to understand the systems and resolve conflicts within those systems. I am Niranjan Ankilla. Focus the systems. Focus on the systems, not just the syllabus. No indefinite silence is allowed. I will see you in the next master class. This is a mark saved in the exam hall. Not about articles, about control of lawmaking. Silence is not the absolute power anymore. Thank you.